Hello, fellow geniuses. Welcome to another episode of Splitting Smart, where Heather and I have candid and informative discussions with divorce and well-being professionals in order to provide you with information that can help support and guide you through your splitting process. I am Lila Aiken Ali, a divorcee, a divorce coach, and the founder of Split FYI.
And I'm Heather Steer, a divorcee, a CDFA, divorce coach, and the other founder of Split FYI. And today we're super excited to have with us Jodi Silbermann, a paralegal for over 28 years, a legal document assistant for over 23 years, or 28 years for the paralegal, 23 years legal document assistant, and the founder of Just Call Jodi. And that's from We to Me, her divorce support coaching program.
And in today's discussion, we will cover what the difference is between a paralegal and a legal document assistant, how they fit into the law firm, and how they can help you with your divorce, and how in some cases you can use them instead of a lawyer, particularly when you want to save money, which who doesn't want to save money? Anyway, welcome, Jodi. We are so excited and grateful to have you and take time again to help define and clarify what a paralegal can do for someone who's going through a divorce or separation.
Well, thank you for having me. I'm so excited. I just kind of jumped in there and I didn't mean to. So thank you both for having me. I'm so excited to be here. So to start with, what a paralegal is the American Bar Association defines a paralegal as a legal support professional qualified by education, training, or work experience who performs substantive legal work that an attorney is responsible for. So a paralegal works directly under an attorney. The paralegal, when you're working with an attorney, they're the primary point of contact for all the files that are assigned. They actively work, file forms with the court, pleadings, motions, and they're your primary point of contact. Whenever you call into your attorney or any paperwork gets done, the paralegal is the one doing everything. They are your liaison between you and the attorney. They handle the paperwork. They'll help you with the day-to-day aspects.
So while you think you might have hired an attorney, you really, a lot of times end up really engaging with the paralegal more.
The paralegal, correct. Because most of the time you're not going to speak with your attorney. You're going to meet with your attorney when you go in to meet. You're going to get your consultation. They're going to talk to you. And then from there, your file is going to get assigned to a paralegal. From there, that paralegal, from beginning to end, if you stay with the attorney for that long, is going to be your point of contact. So anytime you call in, when he's not listening to you or he won't go over the kids, you're going to get the paralegal. And then that paralegal is going to prepare the attorney for court when you have court. Any documents that come in, anything that needs to be prepared is all going to go through the paralegal. So they pretty much are in charge of your case from beginning to end, and they know your case inside and out. Because they're actually working your case. The attorney will give them direction as far as the law and what they want to do, but they're the ones preparing the work and making sure the dates are met, that you're doing what you're supposed to do, and dealing with those day-to-day things that come up every day.
It's your virtual organizer. It's amazing. Well, not
absolutely,
virtual.
Absolutely.
It's amazing.
Yeah, exactly. They are your point of contact, because I don't know if anybody's ever tried to get an attorney on the phone, but it's next to impossible, number one. And the paralegal rates are less than the attorney rates. So they do it also in a way to, try and save you some money. And then on the other hand, there's the legal document assistant, which is also another avenue of saving money, where a lot of paralegals like myself, we go and get registered as what's called the legal document assistant with the county. So in order to do that, we have to provide our education, which requires your paralegal certification and your bachelor's degree and some legal experience. You have to have experience actually working under an attorney. And then you show the county that, and they register you as a legal document assistant, which says it's okay to prepare legal documents. They have knowledge of the court and the system to understand how to prepare and file legal documents. We just cannot give legal advice. So what that means is I can't take the law and apply it to your case. But what I can do is I can explain the law, I can explain the system, I can explain how it works, and I can provide my knowledge and experience, and then you can make an educated decision as to the best option for you to pursue and move forward. You're getting the same knowledge and experience that you get quite frankly, when you go to the attorney, because I'm doing the same role, or we're essentially doing the same role, other than or not under that of an attorney. So on more complicated matters, when an attorney is necessary, and there are times when attorneys are necessary, but they're not always necessary in court cases. So a lot of times that's when the legal document preparation comes in. The legal document assistant, paralegal, can get you through from beginning to end, because we understand what needs to go into the documents, how to prepare them, and how the attorneys prepare them, and how they see things. We understand the language and what they're saying, and we can converse in that and kind of reiterate to you and explain to you in layman's terms what they're saying, and how the process works, and kind of help take some of the fear out of that for far less than you would with an attorney. And quite frankly, you get a lot more hand holding with the paralegal or the legal document assistant than you ever will with an attorney, because they're just not hand holders. Their job is to get you through court, and that's primarily their job. They don't want to deal with all the little things that come up.
That is something that I actually wanted to touch point on. There is a stark difference, and I'm not wholly categorizing all lawyers in one bucket, because there are always different characters out there. But you do tend to find, and I'm glad you mentioned that it is true that they hold your hand. Oftentimes they actually have, even in certain cases, a background in it, like personally.
Correct.
They relate to the person. They really do take that time and make you feel better, because it is a very, when you're sitting in a lawyer's, it's an interesting thing. We've had, lawyers on our show, and, through our community and through our clients, we always hear it's like, oh, they're intimidating. And it's just because they have that badge of attorney, and their language is a bit different. Their approach is a bit different. They do have to kind of create a barrier, because they can't get emotionally tied. They have to be
Yes.
objective, and they have to really talk to the law. And it's really,
Right. And it's hard, because the law has no emotion. Like for me, I understand it. I've been through it personally and professionally. I am a survivor myself of domestic violence, so I understand it from all aspects. And I understand also where the pitfalls are, and I understand how frustrating the law can be. And that's the biggest part. And your lawyers don't necessarily explain it, and they have no emotion, because the law has no emotion. The emotion does not play a part in divorce. While it's 90% of divorce, it doesn't play a part in the legal process. The hardest part of divorce is emotion. 90% of the difficult part, it's 10% paperwork. It's divorce is a business. It's the division of a partnership. When you remove the emotion, it's the breakdown of a partnership. And it's if you look at it in a methodical way and from a legal aspect, that's what they're looking at. They're taking the business and they're breaking down a business, because they can't take the emotions. They can't put your emotions on trial, because California, number one, it's a no fault state. So it doesn't matter whether they were cheating. It doesn't matter whether they were spending money. They can have a credit card in their name, and it's still a community property thing, and you didn't know it. Now, there are issues where they're diverting money and things like that. And those are the issues where you want to get an attorney involved, where they have a second family and they've diverted money, and they happen. But generally, when we run into issues of cheating and those type of things, while I know it's horrible, and everybody wants to go after the other person because of their moral character and things, it's not the court of moral authority, and they don't. It almost makes it worse, because they look at us like, oh, she's just a scorned woman, or things like that, because it doesn't play a part in it. So that's where we can come in and help you take that out of your paperwork, so that your paperwork carries the punch that it needs, so that you get your message across to the judge that has to read thousands of declarations a day, and you want him to read it. And so we really know what they'll pay attention to and what they won't. And so that knowledge goes a long way in helping you.
Could you give us an example, though? Because I think that would be really beneficial. For example, and I don't know if we could use a case to this, but I have seen a lot of people, I've seen clients and friends try to represent themselves, right?
Yes.
And they'll write their deposition, they'll write what they're having to say, and they'll go on, and they're trying to justify their position through it.
Correct.
So what would you do as a paralegal?
Yes.
Would come in and be like, read it all out.
Correct. I always keep it simple, stupid. You have to you can give them a little bit of a flavor so that they can understand what's gone on. You don't want to go into, he said, she said, he did this, he did that. You want to stick to the facts. So for instance, when you're dealing with the kids, a lot of these come down to custody issues. You want to say, I am the parent that wakes the kids up in the morning. I'm the one that feeds them their breakfast. I'm the one that takes them to the doctor and if there's an incident, I always tell everybody, document all your incidents. On November 3rd, we were supposed to go to the doctor and he didn't show up at the doctor. He's continually done that on April 2nd and list the dates that he's done those things. I take the kids to school. He picks them up from school or things that you can directly relate that pertain to the issues that you're directly talking about with the court. Don't talk about his girlfriend. If you're trying to get custody of your children and you don't like his girlfriend, don't throw in his girlfriend said this and his girlfriend said that, because unfortunately they're allowed to have a life. If there's issues of domestic violence and your kid is being violated in some way, that's a whole nother story and a whole different ball game. But what you don't want to do is he cheated and he said this and he's calling me names and if we get into the he calling me name thing, because that it just depends on where if there's abuse there, and you'd have to, I guess, determine that, I guess I would talk to somebody to determine how severe the name calling is. I say that with a caveat as far as the name calling, because there is the typical name throwing that goes on in divorce. Sometimes that's not necessarily equated to the level of abuse. And I think that sometimes that has to be recognized as well, because there's all this contention that goes on and name calling that gets thrown, and you want to keep it as concise as possible. I stick to the facts as far as exactly what's going on. Keep your feelings out of it. Don't put your feelings into the document. And that's what we always try and take out, because you go in, they want a history of your marriage. They don't want to know what's happened the last 20 years. They don't want to know every fight that you've had. They don't want to know you met him here at this, and then you got married, and then you went here, and then the marriage went bad, and then you got back together, and then you had a fight about this the other day. They don't want to hear that. It's like, we need custody. This is what the schedule we're doing, or this is why this works for us, and it's in the best interest of our children. So keep it focused on those things.
What if, oh, sorry, Heather, go on.
I always, when I'm talking to my clients about those kinds of examples of how much you put in or don't put in, I'm like, imagine what these judges are seeing on a daily basis. And also imagine the extremes that they're dealing with. Like, okay, so your the dad didn't show up to the doctor's appointment. The judge is going to be like, yeah, okay, fine, he got busy, whatever. They're used to seeing people that are like, oh, he was shooting up heroin in front of the kid, or left the 2-year-old alone, or did whatever. I mean, these judges are judging, or, those are the kinds of people that they're going to want to deal with. They're not going to want to deal with someone who's not showing up for the doctor's appointment.
Correct. And what I often tell them, and that's where those notebooks come in so handy, is keep track of it so you have a pattern of behavior, because you have to demonstrate a pattern of behavior. You can't demonstrate just one time. And unfortunately, the court system, sometimes the baby has to go out with the bathwater before anybody will do anything. It's the reality of the situation. Then they're like, oh, okay, that baby just went out. Now let's fix it. And it's just the way it is. So I always tell them, give them the rope. Eventually they will hang themselves with the rope, but you have to let it happen. And I think that's the biggest thing, is no one wants to let it happen. They want to go in. He didn't do this, let's go into court. But it doesn't behoove you to do that, because it's just you going in every little thing. And it's like the boy that cried wolf is what it becomes.
Right.
And that's what you don't want to do.
Well, what do you do? And this is an interesting thing, because I often hear this as well, when you're getting attacked from the other side. And so you're trying to justify, or you get into a match of right or wrong, defensive-ness.
Correct.
Oftentimes, well, if he said that, well, I can bring up this, and then I can do this. And that's where it really becomes, because listen, to have both parties with their scruples on and actually behaving is, it's hard to find. So
It is hard.
what-
And that's
what
when I
do you-
sit them down and I'm sorry to interrupt it. I
Yeah.
tell them they have to take the high road. I kind of sit down with them and go through it and say, look, this is your situation and this is what, and kind of break it down. Like, principal costs money. So what is the principal to you and what are we looking at doing? And what is that going to get you? Well, I understand it. The judges are going to hear it and it's just tit for tat is you want it to be done. Everybody wants it to be done, and tit for tat does not make it done. Tit for tat makes it go longer, and it doesn't get anywhere. It just spins out of control. So let's look at really what are we trying to get here? What do we want here? And let's come up with an action plan that actually gets you there. I tell them, put on their Teflon suit. Don't listen to what he says. I don't care what he says. We're worried about our case. Their case is not your problem. Don't pay any attention, because your attorney is not looking at his case. They don't care about his case. They don't even want to hear anything about their case. Don't come to your attorney and say he's doing this. They don't want to, I don't care.
Right.
Your case is your case. Don't worry about what they're doing. And we kind of have to, and I just talk to them and I talk them kind of through it, and try and refocus them on what's important, because I know how that gets. And though that's where it unravels out of control and everything starts to go sideways, and everybody spends unnecessary money fighting, and you're going to end up in the same place that you started with, which is nowhere. So I try and, go through that. And then if they really want to do it and that principle is worth that much to them, then okay, then this is a game plan for that principle. But understand that a lot of these things, you can't do anything with the court. It's while the courts are there, unfortunately, there's only so much that they can do. Really, there's no one policing. Like, for instance, the right of first refusal is a problem constantly, because you're supposed to allow the other party the right of first refusal. Well, how do you police that? And how do you run to court every time he refuses to give you the right of first refusal without looking like you're whining? So you have to keep track of a pattern of behavior. And that's just one little, for instance, because the court gives out gray orders all the time. And there's always these wonky areas, and one sees it one way and the other sees it the other. And it does become an area of contention sometimes. So you have to kind of find
go
that middle
into
ground.
one courtroom and get one answer, go into the courtroom next door, get a second answer, and go into the courtroom next to that, and it's 3 different answers.
Yes. Yeah.
Just for our audience purposes, people who may not have gone through the process of working on custody, right of first refusal is when you can't take your custody hours and you have to get someone to cover that, you go consult with the other spouse in order to get that permission, or to say you can have the kid, you get the first right to have the child versus the other. And a lot of people want to do this and have it be one-sided. And so I always talk to people when we're working on things like that. And it's like, well, what's good for the goose is good for the gander. So
I use that phrase all the time.
You're going to need to also do that same exercise because they're like, well, if he's going to leave the kid for more than 2 hours alone with someone. And I'm like, that's great. Then whenever you're going to do that, let's pretend you want to have a date night or something. Right. You're now going to have to go to the other side and do the exact same thing. So
correct.
It's a dance. It can be, you can have it be more of a handshake rather than written in your agreement, is typically where, what I tell people to try to do, because it's
right. And it always comes down to the parties and how well they can actually communicate and get along
and trust.
It depends on the people. Right. Exactly. And the situation. Some of them can do that great. And then others can't agree. It's Friday on Friday, so.
Yeah.
And that's when it becomes like, what do you want to do to prove it's Friday when it's Thursday?
Yeah, I mean, it's very time consuming, and it's also really energy draining to be in that kind of fight and that constant, proving. I mean, it's way better, obviously, if they can try to get along when children are involved.
And I know you hate your ex.
Well, there's a lot of great ways now to communicate via these portals, apps out there. They're so great, that really help take away the sting and take away that, popping up emails in your inbox, because I know that people have hyperventilation when their ex's name shows up in the inbox, or on the phone as a text message. And I think that there is a good shield. There are creating shields around that. There are great apps around that. But What I really
Sure.
what I wanted to also ask you was, well, also circle back because so if someone were to go to divorce, and I think a lot of people going through a divorce, they always usually start off saying, I want this amicable. I've got kids. We want this process to be good. We don't want lawyers. I know every single person I know has said that. And so, we don't want lawyers. We don't want this because they know where it can go. But, it's one thing saying it in the beginning and the intention is great. But then when finance starts coming up, when child custody starts coming up, with all the things where the emotion starts brewing, it's hard to say, but to do that. But because a lot of people also think there's a misconception that they only can have a paralegal if they hire a lawyer. So explain this process. And also now, we touch pointed on a document assistant.
Legal document assistant.
Right.
Legal document assistant.
Legal document assistant. So what can someone do? Can their first point of contact be actually a paralegal, and explain that process, please?
Okay, absolutely. Actually, I don't know if people are aware, but over 80% of individuals are actually self-represented in the family law process. There are, I think it's 67% of people that file initially are self-represented, and 72% in larger counties are self-represented. And throughout the case, by the time it ends, it's 80%. So absolutely, the legal document assistant actually is a great place to start, because that way you can reserve your money. Attorneys don't have to be there. Most people don't have attorneys from beginning to end. So if there is a place where you need an attorney, you can have an attorney substitute into your case or come into your case at any point in time. So they can get the paperwork started for you. They know the process. They can help you get the person served. They can educate you to how to get through the process, how to get it started, kind of give you an action plan and an idea of what you need to do to proceed and what you're going to do going forward, and even be your point of contact if you need an attorney to help you find an attorney, because many times we have relationships already existing with many of the attorneys from working with them, and we can refer you over. And many times what I will do for my clients, like they will file a motion for court, or we'll get their paperwork ready, we'll get it all ready, and they're afraid to go in on their own. So we'll get them in touch with an attorney, and then I can brief the attorney on what's going on, and then they can have that attorney maybe come in on a limited basis and just appear for them in court. So it's a less costly for them they don't have to have them all the way through, but yet they feel like they're represented and they're not standing there alone against their ex. And then their paperwork's done properly, and then I can brief the attorney. So it kind of works like a symbiotic relationship in cases like that when people want those type of things. But otherwise, they can also go on their own and get themselves through. And I'm going to be honest, I know that the court gives way more latitude to people that are pro per many times. So sometimes it's almost better in certain situations if you're in there by yourself, because you get a little more latitude. Attorneys don't get any latitude whatsoever.
In terms
they
of
can give you
protocols in the courtroom.
Correct protocols, and just missing protocols and doing different things and giving you more time to speak, I guess, to get your point out. But they won't give you that much, but they'll hear you out a little bit as far as what you're trying to do. If you miss a deadline and things like that, they're not going to cut you off at the knees.
And you could help support them on what to say and how to act in it's
that was what I was getting ready to do.
Yeah.
We educate them. When they leave my office, when they get ready for court, they're essentially as prepared as that attorney is going to be to go into court. They have their trial binder, they have everything ready. I talk to them before court, let them know, prepare them what's going to happen as much as I can as to what to expect when they get to the court, what to expect to happen. They have all their paperwork there, everything's been served, so it's right at the ready for them. So they're walking in there as if they are the attorney. They're as prepared as the attorney. So any legal document assistant, I know that's how I do it. I'm not sure how everybody else does it, but they can get their paperwork done and get them into court and have them prepared and versed so that they're educated and can get through on their own without hiring an attorney, or if they want to, again, they can substitute. And there's all kinds of options that they have. It doesn't mean that they have to go spend $10,000 right up front to get an attorney, because the average cost of an uncontested divorce, I want to say it's like $17,000 or between 17,000 and 24,000 for an uncontested divorce with an attorney with children. And that's with no fighting, no bickering, everybody singing Kumbaya and signing.
Yeah.
So, and they don't have to do that. It doesn't have to cost that much. It's just because there are a lot of divorce support professionals like us that are out there that can educate them. And it comes down to educating them about the system. It really does, because fear makes us make bad decisions, and because it clouds our emotion. And so
Education
when
is
our emotions clouded, we make bad judgments when we know better. Sometimes it's because we're afraid, and it's a big deal. It's a whole life transition. So we can see things more objectively than they can. So
I want to go into that nuance of like when you're looking for, I'm facing an uncontested kind of friendlier divorce. My ex and I are like, all right, who can we call? Where do we even start? So I want to touch on that difference between the legal document assistant versus the paralegal, because
okay.
I'm thinking it's sounding like I need the legal document assistant type of person if I'm really just trying to avoid attorneys.
Correct. So the actual difference is the legal document assistant works for individuals. You have to be registered in order to work for the public. You need to be a legal document assistant. You want to make sure that they are registered and have a registration number and are registered with the county as a legal document assistant. A paralegal has to work under the guise of an attorney and under the direct instruction of an attorney. So a paralegal doesn't work independently. I mean, it could be a paralegal, but in order to work for the public, you have to have a legal document assistant registration. You have to be registered with the county.
Physician assistant who can write prescriptions, but the medical assistant cannot. And they have
Correct.
to be underneath someone. Okay.
That's correct. And we're essentially the nursing staff, the nurses of the legal world. We're the ones that do the bedside manner. We're the ones that kind of do everything. They come in with the attorneys come with the advice, the doctors come with the diagnosis. So they come in and then the nurse does everything else. And that's essentially what the paralegal does. They do everything else. So the attorney will diagnose your case. And many times in family law, the paralegals can do that for the most part too. They just can't apply the law to your case. So I can't look at you and go, oh my gosh, you should go file for spousal support because da 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 da. We can look in cases in this, they've, in my experience, most people would file for spousal support in those, and this is your vehicles to do such, and this is how it's calculated. And I can help them run a DISO master and things like that, so they can look at numbers. I'm a numbers person. I don't like to operate without facts. So people come in and they want these things, but they don't really know what they look like. And I'm sure you run into this a lot with the tax deductions. Everybody wants to take the kids as tax deductions, but until you know what that looks like, it may not be your best interest to take those kids as tax deductions. Right. So we can plug them in and then I can show them the numbers and go, okay, this is what you want. And this is some of your options. This one may be better than the one you're looking at. So make an educated decision. Don't go based on what your friend Susie said, because Susie's situation is not anywhere near your situation. And so you don't know what their tax situation is. And that, I think, is my biggest warning to everybody, is don't listen to your friends and your family, because while they mean well, it's only going to send you in the wrong direction.
Don't compare.
Yeah, exactly. Don't compare. I didn't mean to go left on that, but it comes up a lot. So, because undoing is far harder than doing in law. And I see people making mistakes like that because they listen to their friends and they scramble out of fear and do things, and they go spend money on attorneys or do things that they don't necessarily need to do without checking a divorce professional first. I mean, pick up the phone and make some consultations, make your notes, and then make an educated decision before just jumping into anything. And that's why I tell them, even if you're not going to hire me, just make sure you make an educated decision. I just want you to do what's best for you, whomever that's going to be. Make the best decision that's going to get you to where you need to be.
Yeah. So, and I have to imagine that the legal document assistant, if I'm going to go look this up, that there's those across all sorts of different areas of law, right? There's probably bankruptcy ones, there's other types.
That's correct. So you want to make sure they have a legal document, that they are a legal document assistant. You don't want an unlawful detainer assistant that does evictions. You don't want a bankruptcy assistant that does bankruptcies. You want somebody that actually does family law. You don't want somebody that's doing personal injury or just standard document. Right, exactly. That's just typing up resumes or something like that. You want somebody that does family law, that knows the ins and outs of the court. And in particular, your court. Because they have relationships, number one, with the clerks and things over there too, that helps. But they also know how to get to the courts, because each court has their own local form. So you want somebody that's well versed in that. So they know, okay, you're up in Northern California, so I know I have to go here to determine which courthouse you need to be in, number one, so you're filed in the right courthouse. And they have 3 other forms that this courthouse doesn't have, so we want to make sure that we get their local forms. And these are things, legal document assistants and paralegals, they know these things because this is their job, where the general public may not know these things, and they make a mistake and don't do these, and your documents get bounced and you can't get them through the court, and it just delays things over and over, or they serve them wrong. I've seen time and time again people serving their own documents. You can't serve your own documents. You can't just hand them to your spouse and say you've been served. You can't do that. It doesn't work that way. And you can't have there's a protocol. Yeah, and we can get you in touch with that. I mean, and we can make it very simple and almost take the burden off of you. So that way you can focus on those things that you need to, and take the burden of, oh my gosh, what do I do with this? How do I get this filed? What am I supposed to do? We take that burden from you and get you through that process, and kind of help you figure out what your process is, so that you can get through it and sort of navigate through successfully, because it is ups and downs, and every day is kind of a new day.
So could you help somebody, going back to this, because you're California based,
Right.
that's your jurisdiction. However, could you help people in different counties, even though they're not part of your, so to speak, jurisdiction?
Yes.
Would you be able
Yes.
to help? Okay.
Yes, I can do all California. I'm registered for the state of California.
Amazing.
You register just like as a notary, you register where the county you work in when you get your business license, anything like that. I register in my county, that of my principal place of business, but I'm licensed to operate in the state of California. So
Right.
I could coach somebody emotionally out of state for divorce, but I wouldn't even begin to dabble with their courts, because I don't know the
No.
courts outside of California. But what I would do is get them in touch with somebody outside of the state.
Mhm.
Exactly. Yeah. And I have process service, because it happens. I mean, people have properties in other states. So I have contacts all over to handle things like that. But I don't like to start messing with courts outside of state, because I don't know them. So I don't want to make a mistake that I have for somebody. So I send them to someone that knows those courts. But
Right.
California courts, I can get through any California court.
Amazing. What else can we ask? I mean, there's so much in this whole.
I know.
Jodi,
I guess.
well, I
Go
think
ahead.
part of it is this. I think a lot of people come to us for especially, but to anyone, and I think one of the biggest fears is the process. So it is so ambiguous to everyone. Like, you can go online, it's written so many different things. Wait, this form, first of all, you get lost in the forms. Okay. I mean, how many F forms are there? How many this forms?
Right.
I mean, seriously, it's like doing your taxes. So it is really
It
stressful.
is.
Yeah.
It
And
is.
so, and I
And then
always
you have
say,
emotions.
I always say, and now I'm not coming from you, would be better to understand what is the right thing to say in that case. Like, don't worry about all the forms right away. Just do step by step of like where you're at. Do you want to serve, or have you just been served? And then there's something immediate after that. And then just baby step it. Could you just maybe baby step it, so for people, so they can understand that and feel a little bit better?
I do. I break it down, basically just start one step at a time. And the first thing you do is I take a breath, because it's a process, and it's going to be a process, and we'll get you through the process, and you're going to be better for it, I promise. So I kind of take them down, and let's start with the beginning. We have to, first get filed. I explain how the system works. I kind of give them a roadmap so they can see exactly how it works, and the timelines, because there's a timeline for everything. And many times those timelines, I mean, there's very few divorces that happen within that 6-month period. I mean, the reality is it just doesn't. So I tell people, don't expect these, you're not going to be divorced in 6 months. It's not an automatic date. So I kind of tell them what dates to really have to stick fast to, and others that are kind of nebulous out there that will come later. And I kind of educate them to the process. So you start with your petition and start by gathering at home whatever documents you can. That's what I always say too. And anything that's coming in the mail, start making a list. Get a notebook, start making a list of anything that you know of, your bank accounts, savings accounts. You can go room to room and make your list. But as far as the legal process, get someone, I sit down and I even break it down. Let's do the initial part. Let's do your summons petition, get that served. And then this is your homework. You go home and start gathering your financial documents, because very rarely does everybody have it ready all at once, because it's so overwhelming. So I like to break it down from get it served, and then they have their time to get back to you. And then let's work on your financials. Let's get all your paperwork together. Here's your homework. Go look for these documents, and then we'll kind of go over it. If they can't find them or they don't know, we go over kind of what their remedies are, what they can do. And then then write down what is it you want out of this? In the perfect world, what do you want? And then let's work from there and figure out how to get there, or as close to there as we can. And what does that look like? And then figure out a plan to get there. And it just depends on the other side and how amicable the other side is. I always suggest putting a letter together, put it in writing, send them a settlement proposal, throw it all in there. Don't ever give them your bottom line. It's a negotiation. It's a business negotiation like everything else. So once we get to that point, and I don't ever like to do that before you have your financials. I am adamant, like you cannot put the cart before the horse. You can't take a piece of the pie and divide a piece of the pie. You have to know what the pie looks like before you divide it. And so I kind of make them really sit down and look at the numbers and really pay attention to what it is that they're thinking. Look at it in black and white and then make that decision, because it may not look, those numbers that you're thinking in your head may not really be the reality. Let's take the whole pie and put it in what's called a profitizer, and that divides everything up so you can see what your whole piece looks like. Because if you just get this car and he gets this and you get this and you get this, and at the end of the day we're like this and everything's gone, now what? You can't go back and undo. So those are I break it down in steps. First, let's do the initial. If you guys are in agreement, great. He doesn't have to file a response. Where are we with the parties? Let's get your financials done. Okay.
What does that mean? If he's in agreement, you don't. So if you're doing an initial, like let's say I'm filing for divorce. I want to divorce my husband, and I go there and I go to you and I said, okay, help me with the process. I'm going to take me as an example. I really want to break it down so people can understand, what's first and then what's second. So it's like you come to you and then you file. You petition.
And then we get them served. We filed the petition, the initial petition, which tells the court, I'm suing the other party for divorce. And these are all the issues that are included in my divorce. So we file your initial petition for dissolution. You file that. And then there's other forms, local forms that they require with that your declaration of residence. And if you have an attorney, and then if you have kids, you also have to file your declaration regarding uniform jurisdiction of Children to Minors Act, that one. So you let the court know where they live, so they have jurisdiction over the kids. You get all that filed with the court. And until they're served, there's no court case. Once they're served, that's when your clock starts ticking. So you have to have the other party served by a third party, somebody over the age of 18 that's not a party to the action can serve the paperwork. It can be anybody over the age of 18 that is not involved in your court case. So it can't be, I wouldn't use your stepson who's over the age of 18 just because they might come in. It can be your friend. It can be your cousin. It can be, the guy down the street, or it can be a process server. And they are basically professional people finders. So you give them the information as to where the person is, and you give them some details and they'll get them served. They'll figure out, they'll find out times and dates, and it doesn't have to be a big deal. Some people will avoid service and some won't. Sometimes people will know it's coming and you can arrange to have it done. So I go over that with the people. Does he know service is coming? So I will arrange it with the person that I'm working with, and also so that they know that it's coming, so they know when they're served, so there's not this big surprise like, oh my God, and now we have a whole big bang. So my client will know when the surface is going down and how it's going to go down, whether it's a process server is coming out of nowhere, or someone's going to show up at their door at this time and they know it's coming, or they're going to show up and I'm going to hand them the paperwork. I mean, we can do all of those things. It just depends on, it all boils down to people most of the time and how, in the situation, because every situation is different. So I try and just get to a feel for my client and get to know where they're at. And if they don't know, then we'll go through it and I'll say, these are your options. And it sounds to me like maybe, you want a process server, you don't want to do this. What do you think you want to do? Because they know how much contention there is or where they're feeling, if they're going to accept the paperwork or not. So then we start there, we get them served. Now they're served. Now we see whether they're going to file a response or whether they're talking together to see, are they working together? Because every situation is so different. I mean, some people are still living in the same house. Some people can't talk. Some people are talking to try and work stuff out. Some people are moving furniture together. Some people are moved out of the house and they can't get to anything. So it really depends on their situation. So many times at the beginning, we will also file what's called a request for order, which is a motion for custody, visitation, support to get you your money and those things in your home at the beginning. And we'll file that with the motion, and we'll file that and serve it with the motion. And most of the time when there's kids involved, we'll do that. And another reason is when you're filing for custody, because you want to preserve your retroactivity also. So your support doesn't kick in. You can't, when you file your motion for support, that's what sets your timeline for support. Let's say I need support and I wait 3 weeks to file support. I can't go back and say I needed support for all those weeks. I can only go back to the date that I filed my paperwork. So, and let's say I'm not going to get into court for 90 days because the court does not see support as an emergency. Ever, never, 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 never will you get into court on an ex parte for support, because they'd all do it. So the court does not see money as an emergency. And that's the first thing people need to understand, because while it is a dire emergency for everybody, the court doesn't see it that way. The court does not see it that way.
Talking divorce lingo, what is ex parte?
Oh, an emergency hearing. I'm sorry. And it's an ex parte is an emergency hearing when you need to get into court right away. And there's a set of an emergency circumstances. It's like, oh my gosh, judge, I don't know what to do. I'm going to lose the house tomorrow, or he's taken my kids, or there's some emergency issue. You can file what's called an ex parte hearing with the court to get into court, or if there's something going on with their kids, if there's some emergency, to get into court, to get an emergency court order. You file that with the court. They then determine whether you have what's called exigent circumstances, emergency situation, to be heard right away. And unfortunately, the court does not see money as an emergency. So what happens is the first thing people do is they starve you out and it becomes an emergency. And that's why filing the motion, the request for order, and you'll hear the term RFO, is filed, because it preserves that. So once it's filed, your support will be retroactive, meaning dated back to the date of filing, depending on if you filed it before the 1st or the 15th. So that way, by the time you get into court, even though you haven't gotten any money, you're going to get your money.
Right.
You know what I'm saying? So it's still accumulating, depending on where your order is going to be, it's still accumulating. So, but if you haven't filed any paperwork, it's not accumulating until you file it. So many times, depending on the situation, you want to get that filed right away. Number one, because we want to make sure that the kids are protected and that everybody has control of the kids and where they're going and what they're doing, and that we can get your money flowing as soon as possible.
And even if you don't know what all the assets are, you can still file for temporary support orders until all of the deck chairs.
Everything's done. So at any point in time during your divorce, you can file. If you need relief from your court, you can request what's called pendente lite orders, temporary orders, and get temporary relief from the court, so that for your support and custody, until you reach a final agreement, your final judgment, and everybody signs off on it, those orders, and they could change constantly throughout until you reach the end. And that's kind of what helps you take the, it's like the principal coming in. If everybody can play by the rules, then and get along, then it's fine. It's when you can't play by the rules and everybody doesn't get along in the sandbox. It says, okay, these are the rules you got to play by. Then play by these rules, and you got to stay within this box. And that's kind of what happens when you have to go to the court to get those.
You can actually
But-
file that. Going back to this, when you do file the petition for divorce.
Yes.
So
Right at the
all
beginning.
Wham
Yes.
bam. And
Wham bam.
when you file and the other person has been served, and they can sit on it and not declare that they've been served, or does the petition,
Oh.
does the person, does it go to court? When does it go to court? Because this is where a lot of people get very confused. Well, what
Right.
if they just sit on it, don't sign it and hold on to it? Does it mean that I don't have a court case? So.
Okay, no. Okay, so they don't ever have to sign it. So first of all, parties never have to see the inside of a courtroom ever. But if the other party does not cooperate and they refuse to cooperate, then the petitioner can proceed on what's called a default. So the other party has 30 days to respond to the petition. If they don't, then your paralegal will help you, or your divorce support professional will help you file the paperwork for what's called that would be a true default, where you have to put in all your paperwork. You have to let the court know what assets you have, what debts you have. You have to disclose everything to the court, and you put in your proposed settlement to the court. And then you submit all that to the court. And typically in those situations, the court will set what's called a prove-up hearing, and in those situations where it depends on what kind of assets there are, but you will then have to show why it's amicable, and then you'll get your judgment. In cases where the other party if you can reach an agreement, and you are communicating, you can still do what's called a default with an agreement, which is your best bet. Because if you do the default, the first default, I'm gonna backtrack for a second. The first default, where they don't answer and you're doing a true default, and first of all, those are very few and far between. I'm going to tell you, the reality is they're very few and far between, where they're completely in the wind and there's no communication. There may be no answer, but there's usually something. They're usually communicating somehow, and you can usually get an agreement, usually have a settlement agreement. There are those times where you have the true defaults, where you're putting everything into the court and you do that. But then there's also the risk of the set aside that comes in if they do those things, because the other party is able to set it aside. They have a whole time period to do that. So there's risk factors with that too. Sometimes you have to do it, but it's not signed, sealed, and delivered until that time passes. It can still be set aside. So typically you like to get an agreement with a wet signature on it, because that's much harder to set aside.
Right.
And you can still do that back to the uncontested. You can still do that uncontested, where only one party has to file. You can both agree. You disclose all your financial documents, and you sign what's called the marital settlement agreement, where everything that you guys discussed and you actually agree to, you spell it out in black and white. Everybody signs it. It gets notarized, and that becomes your judgment, and that becomes your governing document. And that's your final divorce decree that governs everything.
But they cannot bypass or skip the financial disclosure. Am I correct?
No. California is full disclosure, and there is a consequence for leaving assets, for not disclosing assets. You will most likely lose that entire asset if you don't disclose it. And California does not take that lightly. It is full disclosure, and there's always a way. If somebody's hiding assets, there are ways to find it. Everything costs money. It all costs money, and it does get expensive, and it's very time consuming, and it doesn't happen overnight. But there are ways to do it. And I hear a lot of times people get worried they're going to hide money and do all these things, and they get all worked up over things because people are telling them, and 9 out of 10 times it's not really happening. Because listen, especially in these days, it's hard to hide money. Everything has a trail. Unless you have cash, you're not hiding anything. You're not going to get away with anything. And so you start playing those games, and there's things called sanctions, and the court will, and that's like a slap on the wrist, and the court will fine them monetarily and give you that money. And I had to do that quite personally with my ex. He refused to sign for my house. He refused to sign the papers. We were in escrow and he refused to sign the paperwork to finalize it. So I had to go into court on an emergency hearing on an ex parte and ask them to have what's called the court elizer sign on his behalf, which means the court has an elizer. And if you request them to have this person sign on your ex's behalf because they're refusing, and these are things that your divorce professional will know, that the general public doesn't know about these things. So some attorneys don't even know about it, quite frankly. But you can do that. You can ask that, look, he's refusing to sign. I'm in escrow. I already have orders. I need the court to sign on his behalf. So you have the court elizer sign. I had the court elizer sign on his behalf, and the court sanctioned him $5,000 that he had to pay me because I had to go to court and I had to do all these things because he was intentionally forwarding the process. He was intentionally stopping the process of settlement. And if they do that, the court doesn't like that. They want you to settle your cases. So if they're intentionally doing things to prolong your case, there's remedies for that. And so that's where your divorce support professionals will come in and they'll help you successfully do those things. And also put in the language that's necessary. For instance, when you're filing your motion for kids, people don't know that there's specific language that you want to have in there so you can make sure your witnesses get in there and things like that. They don't know that, and they don't have that language in there because that's attorney language and things like that. And it's language that you know about because you know it needs to be in there, and they're not going to tell you, but it's in all my documents because it's standard protocol. So it's those things that it's that experience that people tend to think where we're just filling out boxes and we're just filling out forms. And there's a lot more than just filling out the forms that goes with it. It's the knowledge and the experience and understanding and making the judges, like you said, pay attention because they read thousands and thousands and thousands of these a day. So you want them to pay attention to what you're saying. You want them to hear you. And that's where we can come in.
They're hard, honestly. Like you go in, and I'm a pretty literate person, but when you're reading these, they have to create a document that applies to so many different scenarios that you're like, oh God, does that box apply to me or not? Like, why are they even asking me this question? Like, it's so foreign because it's something that totally doesn't relate to your life. And just having that confidence of talking to someone like you, where I'm like, what does this really mean? And should I check that? Like, what, I mean, I had such a fear looking at those documents and going, what am I giving up? You know, because I think there is a risk. You can really screw yourself.
There's a huge risk. And I'm going to tell you, touching on that, there's a huge risk. And I see it time and time again. And I've even seen attorneys do it. Any good attorney and any good paralegal that's doing their job, when you file your petition, you're going to check all the boxes. I don't care if you're asking for support or you're not asking for support. We're not asking for support, so we don't need to. That's not asking for support. That petition is giving the court jurisdiction over those issues. So if you don't check the box of support, well, guess what? You are never going to get support. The court can't even make an order if they wanted to. And just that one little box is a big deal. And people will think, oh, I don't want support, or that's going to make him mad. And it's not giving you an order. It's not doing anything other than saying, hey, judge, I'm going to need you to make a ruling on this at some point down the line. And if you don't ask for it, you're never going to get it. If you don't put attorney's fees in there, you can never go ask for it. So, and then when you go to do your judgment, you need to make sure that all the boxes that are checked here are addressed here, or it won't go through either. So, I mean, there's all these little nuances. It's more than just that box means something. That box has a huge meaning attached to it. So it's important. And sometimes they think that it's so easy, just check, okay, well then, it's I've seen many mistakes happen. And like I said, it's harder to undo than it is to do in the legal process.
And I think that's where, whenever anyone says, hey, do you think I can just file it on my own? I'm like, no, I don't think that's a great idea. You should really consult someone, which is going back to looking up a legal document assistant.
And it is. And it's just like, our emotions cloud our judgment, which is why attorneys shouldn't represent themselves, because they don't make the best decisions, and doctors aren't their shouldn't be their own patients, because when we don't see ourselves, like when I was going through my divorce, I'd go to my boss and he'd look at me like, what would you tell your client? And well, that applies to them, that doesn't apply to me. So because it's very hard to apply those, because fear and those things go along with it. So I think that objective and the experience goes a long way, and will in saving you a lot of money, headache and heartache and stress, honestly.
Absolutely.
They're making a lot of noise outside of my house, so I'm not going to be able to talk too much more. But I wanted to say thank you, Jodi, because once again, you have even educated me more on the whole process, because there's so much that goes in it. I feel even better when I'm even helping someone to just say, okay, these are the outlines of things, but please contact someone like Jodi, contact Jodi. We would love to get your information just so we can tell the audience where they can find you.
Yes.
And, if they do have questions, I know you're so open and receiving and
Absolutely.
helpful for people who are really just need to understand, can they use you? Can they use a paralegal? So with that, I'm just going to say, because the noise is unbearable, but with that, I'm just going to say thank you. And I'm going to let Heather take over, and I'll just smile.
Thank you.
So how do we get a hold of you?
Okay, I'm going to go ahead and put my stuff in the chat right now.
Perfect. And then also, I think a really great future, this is now going to be my house, discussion is divorce lingo. So
yes, I think that would be great.
And, because it does come up and it is those things. So I would love to be able to have you come back and do that with us.
Okay, I would love to do that. Let me, hold on. I can't talk and type at the same time for some reason. It's too. Yes, what I will do is actually, I've been working on putting a list together anyway. I'll put a list together, and then if you have any that you can think of that you want me to, I'll make a list together. I think that's a great idea. And I apologize. I don't mean to talk like that, like in the terms. I just so naturally, sometimes I forget that that people don't know the term.
Well, you've got divorce lingo inside of your world, so it's normal.
Well,
yes.
and
Right.
Like you go into an attorney's office and they just do that. And I think it's good for our audience. That's why I would stop you.
Yeah.
And, because it is this thing where, and I do it like any industry,
right.
You have your own acronyms and your own language. And,
right.
Hopefully you haven't had to deal with a lot of attorneys unless it was in your day-to-day work, but
right.
That's a part of the education. So I think that would
Absolutely.
be a really cool conversation for us to have. Let's talk about depositions and subpoenas and,
I think so too. And I think that'd be a great idea, in discovery and all of those things.
Yeah.
I think that's a great idea. Absolutely. Okay.
Thank you.
I would love to. Thank you for having me. I enjoyed it once again. I love it every time.
JustCallJodi.org is the website. Info at justcalljodiinc.com.
Yes.
Or at 951-297-9335. And we'll also have this.
We'll have in the show notes.
On the YouTube notes.
Perfect. All right. Yeah. So that I got everything else set up. Thank you. I enjoy this very much. I enjoyed having me.
Yeah.
All right.
All right. We're signing off for today, but hope everyone has a great week.
And will you send me a copy also?